president improperly holds classified documents. No, not that one, this one. Now, we've talked about the hot water that former President Trump is in for holding on to /stealing classified documents. And now President Biden has made headlines by potentially doing something similar. Is this a big deal? Or rather, how big of a deal is this? Our resident criminal law expert Spencer takes a deep dive into Biden's hot docs.
Truly, who among us does not have top secret documents accumulating on our nightstand like dirty water cups? Joe Biden is in hot, or at least, like lukewarm water for having classified documents in unsecured locations. And Attorney General Merrick Garland has appointed a special counsel to look into the matter. So what's the deal with these classified documents? And how are they different from the Trump situation at Mar-a-Lago? And how are they the same? Let's get into it. So a little background. The timeline of Biden's documents is as follows. On November 2nd, 2022, Joe Biden's personal attorneys find classified records from Joe Biden's time as vice president at Biden's office at the Penn Biden Center in Washington, D.C., a think tank sponsored by the University of Pennsylvania. According to Richard Sauber, special counsel to President Biden, the documents were discovered when the president's personal attorneys were packing files housed in a locked closet to prepare to vacate office space at the Penn Biden Center in D.C. Biden's attorneys informed the National Archives and Records Administration, or NARA, of their discovery that same day. Now, as an aside, for those of you who feel like the last 3 COVID years have stretched into a bleak eternity and basically lost all sense of time,
time is a flat circle.
Joe Biden was Barack Obama's vice president from 2009 to 2017. Then Trump beat Hillary in 2017, had really quite the term in office, and then Biden was doing his own little thing over here, and now he's president and Trump isn't. Okay, back to the story. The next day, NARA refers the issue to NARA's own Inspector General, who in turn passes the matter on to the Department of Justice on November 4th. The DOJ and the FBI immediately began investigating the matter. Meanwhile, Biden's attorneys find more classified documents at his garage at his personal residence in Wilmington, Delaware. According to Bob Bauer, one of Biden's attorneys, they remain in close contact with the DOJ and NARA throughout this whole referral and investigation process. Now, over the next month or so, a handful of additional documents are found in the Wilmington house. At that point, Attorney General Merrick Garland reviewed the special counsel regulations, which say that when matters are brought to the attention of the Attorney General that might warrant consideration of appointment of a special counsel, the Attorney General may direct that an initial investigation consisting of such factual inquiry or legal research as the Attorney General deems appropriate be conducted in order to better inform the decision. Garland followed the regulation and directed U.S. Attorney John Losh to make the initial investigation. When Losh told Garland that further investigation by a special counsel is warranted, Garland appointed Robert Hur as special counsel for the matter. Now, Hur is a former U.S. attorney for the District of Maryland and worked as principal counselor for Rod Rosenstein, then the Deputy Attorney General, before moving into private practice. Maryland Senators Chris Van Hollen and Ben Cardin, both Democrats, as well as Republican Governor of Maryland Larry Hogan, have all vouched for Hur's capability and work. All told, CBS News reports that the total classified documents found in Biden's possession number around 20, some of which are top secret, the highest classification. It's unclear who visited Biden's home or office while the documents were there. Official residences like the White House have thorough visitor logs that are sometimes publicly available. Dick Cheney. But that information isn't kept for Biden's private residences or offices. The issue with Biden's documents is different than Trump's at Mar-a-Lago for many reasons. But the biggest one is that Biden and his lawyers have apparently done nothing but cooperate fully with NARA and the DOJ, as opposed to, say, repeatedly refusing to give up knowingly purloined documents to their rightful owner, thus forcing an FBI raid on your home. Then, say, just as an example, having your lawyer lie to said FBI about the existence of more documents. That would just be nuts, right?
Now it's invisible classified documents.
Plus, I'm sure that Joe Biden has already declassified everything with his mind. So problem solved. Joking aside, having classified documents at your home or office is no laughing matter. It could have potentially serious implications, both criminally and politically. So let's dig in. Now, what's really at issue here? Unlike with Trump, whose Mar-a-Lago shenanigans touched on many possible crimes, from false official statements to obstruction of justice, the Biden situation at this point seems like it really might only implicate one criminal statute, the Espionage Act. The Espionage of 1917 was passed, as the name suggests, during World War I. At the time, President Woodrow Wilson was deathly afraid of foreign-born American citizens seeking, and I quote, "to bring the authority and good name of our government into contempt, to destroy our industries wherever they thought it effective for their vindictive purposes to strike at them, and to debase our politics to the uses of foreign intrigue." The act has long been criticized for being poorly written, chilling of free speech, and a tool of intimidation. But it's on the books, so here we go. The Espionage Act is codified under 18 U.S.C. 793 and contains a number of different crimes involving information related to national defense. There's one key word that we're going to be using, and it's used throughout the literature about the Espionage Act, and which, conveniently, never actually appears in the statute. And that's National Defense Information, or NDI. NDI means information relating to national defense that could be used to the injury of the United States or to the advantage of any foreign nation. NDI can be found in many forms: blueprints, codebooks, photographs, sketches, whatever.
You see everything. You see the big board.
Now, the courts have cabined that definition a little bit for prosecutions under the Espionage Act. To prosecute someone for, say, transferring or mishandling NDI, the NDI has to be closely held. Now, that's not in the statute. It's a court-created rule to get around First Amendment concerns and some other challenges. Basically, closely held means not publicly available. Obviously, if the DoD issues a press release talking about how Fifth Fleet is steaming towards Bahrain, it's no longer closely held information relating to the national defense, so it's not NDI. But it's actually more than that. It doesn't take a press release to make something no longer NDI. NDI is information that has not been made public and is not available to the public. For example, the gym schedule on a military base. That may not be available to the public in the sense that it's like on a website, but there's no prohibition on service members on that base communicating the schedule to their friends or partners or spouses. And when you look at it that way, it's sometimes helpful to identify NDI as something that is actively withheld from the public. And that is how we get to classification. The Espionage of 1917 doesn't talk about classification. It doesn't distinguish between secret or top secret or no foreign or Five Eyes or whatever. Instead, for the purposes of prosecution under the Espionage Act, classification is circumstantial evidence that a document is closely held. In other words, you classify NDI, and classification markings indicate that it's NDI. But to be clear, you don't need classification markings for NDI, it's just really useful. Before we head into the actual criminal components of the Espionage Act, it's worth saying this. The Penn Biden Center and Joe Biden's residence are not lawful places to store NDI. The possession of NDI at those locations is generally not authorized. So, is there a crime? The Espionage Act, 18 U.S.C. Section 793, contains a bunch of different crimes. Now, no one is claiming that Biden flew over a submarine base, snapping photos with the intent of passing those photos to, say, Peru. So let's start with subsection D. When you lawfully have possession of NDI, it's a crime to do one of two things. First, willfully give it to someone who's not entitled to receive it, and second, willfully retain it and then fail to deliver it to a government employee upon demand. Let's call this the spy provision. I think it'll make sense. You're working in a government office. You lawfully have access to some top secret information and you pass it off to your Peruvian handler. You just violated subsection D. Or maybe you walk out of the office with a thumb drive full of top secret material that you're, otherwise allowed to have, and your supervisor comes running out after you, yelling that she knows what's on the hard drive and that you need to give it to her right now. Well, if you respond by running off to your beat-up Geo Metro that you can barely afford on your government salary, you have also violated subsection D. And that takes us to subsection E, because with subsection E, the starting point is having unauthorized possession of NDI. If you have unauthorized possession of NDI, it is a crime to willfully give it to someone who's not entitled to receive it, or willfully retain it and fail to deliver it to a government employee entitled to receive it. So obviously that first part is basically the same as subsection D. It's just that you aren't entitled to possess the NDI in the first place. So if you pick up a folder marked top secret from the floor of the DC subway, you can't just sell it to the Fijian embassy. In fact, it's worth noting that for subsection E, there is no requirement, like with subsection D, that there be some demand from a government employee to return it. If you have unauthorized possession of NDI and you fail to deliver it to a government employee entitled to receive it immediately, you just committed a crime. So when you find that folder, marked top secret, on the floor of the DC subway, you better just walk that thing over to the closest FBI office and no peeksies. You'll be fine. The person who dropped it, they're going to get fired. At best. So let's bring this back to Biden. Subsection D presumes lawful possession of NDI, while subsection E presumes unauthorized possession of NDI. But both statutes rely on willful conduct. You're either willfully giving NDI to someone or willfully retaining it and not returning it. The key word here is willfully. And the courts have held that in this context, willfully means having designed to mislead or deceive another. That is, not prompted by an honest mistake as to one's duties, but prompted by some personal or underhanded motive. And at this stage, with the limited information that we have, it would be really hard to attach such a motive to Biden. What we do know is that his lawyers contacted NARA in November to report that they had found NDI at the Penn Biden Center, and then made additional reports for NDI found at Biden's home in Delaware. Regardless of whether we look at this as unlawful transfer of NDI or as unlawful retention of NDI, it would seem that the government would have a hard time proving willfulness, given the information we have. There's another issue. What makes possession lawful versus unauthorized? In other words, does a former vice president fall under subsection D or subsection E? Oddly enough, that might depend on a clock. Specifically, the National Institute of Science and Technology's NIST F1 cesium fountain atomic clock. That clock sets the US's official time and is so precise that it won't gain or lose a second in 100 million years. So why the hell are we talking about an atomic clock? Well, because the official transfer of power between the Obama administration, where Biden was vice president, and the Trump administration, where Biden was just a cool dude washing his Camaro in a tank top and denim cutoffs, happened at exactly 12 o'clock p.m. Eastern Standard Time on January 20th, 2017. At exactly that moment, when the cesium-133 atom vibrated just so, Vice President Biden went from a top-level classification authority to, well, just a dude with a car, a hose, and some soap. Now, as far as subsections D and E go, it kind of doesn't really matter. Let's say the NDI materials were transferred to the Penn Biden Center or Biden's residence before Biden legally left office. Then maybe he falls under subsection D, having had lawful possession of the NDI materials. But the ultimate question will be whether the transfer or retention was willful, regardless of whether it's under subsection D or E. And that standard requires more than an honest mistake. It requires a personal or underhanded motive, which, with the limited evidence we have, just doesn't really seem to exist. Maybe he was biding his time until a national ice cream shortage to jump ship. So if subsections D and E are kinda off the table, what's left? Well, there's one more subsection of the Espionage Act worth looking at. Instead of the starting point of lawful possession for subsection D or unauthorized possession for subsection E, subsection F's starting point is this: being entrusted with or having lawful possession or control of NDI. Now that's a little bigger than just lawful possession, and the meaning of being entrusted with hasn't really been explored much by the courts. Let's just assume, for the sake of argument, that, atomic clock notwithstanding, Biden was entrusted with or had lawful possession or control of the NDI at issue. Again, that's just an assumption. Well, once you assume that, it's a crime to do one of two things. First, if you, through gross negligence, permit the NDI to be removed from its proper place of custody or delivered to anyone in violation of the trust, or be lost, stolen, abstracted, or destroyed, that's a crime. Second, if you're a government employee and have knowledge that the NDI has been illegally removed from its proper place of custody or delivered to anyone in violation of its trust, or lost, or stolen, abstracted, or destroyed, and you fail to make a prompt report of it to your superior officer, that's also a crime. Let's start with that second part, the government employee one. The text of that part of subsection F requires that a person make a prompt report to a superior officer. If you believe Richard Sauber, the special counsel to President Biden, they found the documents at the Penn Biden Center in a closet during a move of office space on November 2nd, 2022. At that time, Biden was president, so he doesn't really have a superior officer. So, arguably, this part of subsection F doesn't really apply. But even if it does apply, they did make a report of it to NARA immediately. So that seems to comply with that second part of subsection F. As for the first part of subsection F, the question is really whether Biden, through gross negligence, permitted the NDI to be removed from its proper place of custody or to be lost, stolen, abstracted, or destroyed. That last thing, lost, stolen, abstracted, or destroyed, I mean, that probably doesn't apply, and that's kind of generous because who knows what abstracted means. Maybe it's like when you turn NDI into a performance art piece or something. So what remains? Did Biden, through gross negligence, permit the NDI to be removed from its proper place of custody? I mean, that sure sounds good if you want Biden to be guilty of a crime under the Espionage Act. I mean, if he has NDI at his house, how could that not be grossly negligent? Well, bad news. Gross negligence is actually a pretty high standard. Negligence itself is basically a failure to accord with the standard of care. You're in a particular situation, you're supposed to be careful in a certain way, and if you're not careful in that way, then it's negligent. Gross negligence is an extension of that. It doesn't have one single uniform definition, but you could probably sum it up as a wanton or reckless disregard for a standard of care. Here's an example. You're a paramedic on duty, and instead of listening to your radio, you're smoking and joking with your buddies, and you miss a radio call and someone's hurt. That could be negligent. There's a standard of care to listen to the radio on duty, and you're not meeting that standard. Now imagine the same situation, but you, the paramedic, decide to turn the radio off entirely, so it doesn't interfere with your little personal time. That could be gross negligence, because you're not just failing to meet the standard, you're actively going against that standard, knowing what the consequences could be. Given what we know, does Biden meet that standard of gross negligence when it comes to NDI? I mean, probably not, based on what we know so far. We don't know much. I mean, who knows what Dark Brandon's up to? The information we do have mostly has to do with the discovery timeline of the NDI materials, not how the materials got to the Penn Biden Center or Biden's residence in Delaware in the first place. Was it movers? Was it Biden's direct subordinates? Was it Biden himself grabbing documents from the Resolute desk on the last day like a high school wrestler at the last call at the buffet? I mean, we just don't know. But the standard for gross negligence is so high that it would require some incredibly compelling evidence to show that Biden wantonly disregarded the standard of care with respect to how NDI materials should be handled. That evidence hasn't been released yet, that's for sure. Now let's step back for a second. We recently discussed the reasons why Merrick Garland appointed a special counsel over the Trump matters. The same rationale applies for Biden's special counsel. When there is an apparent conflict of interest or special circumstance, the regulations require that the Attorney General appoint a special counsel. 28 CFR 600.1 states, "The Attorney General will appoint a special counsel when he or she determines that criminal investigation of a person or matter is warranted, provided the following conditions are met. Investigation or prosecution of that person or matter by the Department of Justice would present a conflict of interest for the department or other extraordinary circumstances. And that under the circumstances, it would be in the public interest to appoint an outside special counsel to assume responsibility for the matter." Although Garland didn't say that it would be a conflict of interest for him to criminally investigate his boss, that is a textbook conflict of interest. Instead, Garland invoked the first condition, that there were extraordinary circumstances. Now, I suppose that we could quibble with the meaning of extraordinary circumstances. But let's be real. We live in a world where two senior citizens who have been presidents both had classified documents in their private residences. One of them was subject to a search by the FBI, and both are running for president again in 2024. That's extraordinary. And it is in the public interest to have impartial investigations into both situations. It would not have been right for Garland to personally investigate and make decisions about criminally prosecuting Biden. By appointing her, Biden and Trump are being treated equally. Well, treated kind of equally. Because when we're talking about possible criminal consequences for Biden, unlikely as they are with the facts that we have to keep in mind that he is right now, and you may not know this, the President of the United States, and Trump is not. And it is long-standing DOJ policy that a sitting president cannot be federally prosecuted. So even if, and I really stress that if, Biden were somehow criminally culpable, federal prosecution couldn't happen until he's out of office. Trump, meanwhile, could be prosecuted right now. But because Biden is the sitting president, there's something that could happen to him now that can't happen to Trump: impeachment. Of course, to be fair, Trump was impeached twice, but honestly, it seems like a lifetime ago. House Republicans are already gearing up for their own investigation, and it's not like House Republicans weren't already itching to impeach. If it wasn't this, it would have been something out of the Hunter Biden extended universe. Proving that Biden was grossly negligent to a jury would be vastly different than proving the same thing to a majority Republican House. So that's where we are. The differences between the Biden and Trump situations are substantial, and those differences really impact any theoretical criminal liability. But we don't have all the facts right now, and chances are good that the House Republicans are going to drive towards impeachment regardless of what Special Counsel Hur discovers. At this point, it's a waiting game.
Yeah, and now we have even more news. Just days after Garland appointed Robert Hur as special counsel, the FBI searched Biden's Wilmington home for more classified material, and they found it. The search took 13 hours, and the Justice Department removed, quote, 6 items consisting of documents with classification markings and surrounding materials, some of which were from the president's service in the Senate and some of which were from his tenure as vice president. And the FBI also removed some personally handwritten notes from Biden's vice presidential years. Prior documents were found in Biden's garage, but investigators have not revealed where the 6 items were located. The Justice Department confirmed that Biden invited the FBI to search for documents. There was no search warrant, and Hur did not request access to the house. This was the 4th batch of records found in Biden's possession since November. We also learned a little more about why Biden's lawyers did not immediately search the garage earlier. They thought all the file boxes had gone to the Penn Biden Center because that was the impression they got from the officials working in the presidential transition in 2017. But these new facts make the Biden case look a lot like the case of former Attorney General Alberto Gonzales, who worked for George W. Bush. In 2008, an inspector general found that Gonzales had improperly stored classified documents at his home and work. In 2004, when Gonzales was the White House counsel, he made notes about a classified NSA briefing and kept draft opinions about a detainee interrogation program and kept other memoranda describing legal and operational aspects of the 2 classified programs. And when someone writes notes about classified documents, it renders the notes classified as well. And like Biden, Gonzales took his notes to his house. Some of the notes contained top secret SCI information about the NSA code word surveillance programs, and Gonzales wrote the top secret code name of the program on an outer envelope. He stored the notes in a briefcase. And after Gonzales was appointed as Attorney General, he took the notes from his private residence to his office at Main Justice, where he failed to store them in a skiff. The IG discovered 17 more classified documents marked top secret SCI in Gonzales' office safe, which was not an approved location to store them. And several employees without the necessary security clearances had access to them. Gonzales did not self-report the missing documents. He claimed to be unaware of their classified status, but there was some evidence that he did in fact know how sensitive they were. He wrapped the notes in 2 envelopes and wrote AG Eyes Only Top Secret on the outer envelope. The Inspector General found that Gonzales mishandled classified materials. Nonetheless, the Department of Justice declined to prosecute Gonzales. They analyzed his handling of the notes under the gross negligence provision in 18 U.S.C. 793, and although prosecutors could probably show that Gonzales' documents were removed from their proper place of custody, as Spencer explained, they would have a hard time proving the required constituted gross negligence. Proving criminal recklessness is a really high bar. Gonzales claimed to be unaware that the documents were classified, although his notes suggested otherwise, while Biden said he didn't know a locked garage wasn't a proper place for the documents, and common sense would seem to suggest otherwise in that case. Although you could conclude that both of these guys should have known better, their claims still present a problem for prosecutors who need to prove intent. And the Gonzales declination suggests that the DOJ will not prosecute Biden in this case as well, based on what we know so far. Gonzales cooperated with the IG's investigation by turning over documents and allowing the searches. Biden, like Gonzales, has not attempted to obstruct their return. Dick Durbin said that, quote, when that information is found, it diminishes the stature of any person who was in possession of it because it's not supposed to happen. Whether it was the fault of a staffer or an attorney, it makes no difference. The elected official bars ultimate responsibility. And ultimately, national security law expert Brad Moss is probably right here when he says, Biden's sloppiness with how he handled classified document storage over the years is a problem of his own making. The FBI investigation into it is fully warranted. Whether he is vulnerable to criminal liability remains to be seen. So we'll see what kind of penalties are handed down to Biden or his staff for leaving classified documents at Biden's Delaware home. And breaking news, classified documents have been discovered at former Vice President Mike Pence's Indiana home because apparently everyone has classified documents at their house now. Just 1 week after Garland appointed Richard Hur as special counsel in the Biden case, Pence asked an attorney to review 4 boxes stored in his house, and lo and behold, there were about 12 documents with classified markings. The FBI and the Justice Department's National Security Division have launched an investigation. Now, Pence's lawyer wrote a letter to NARA explaining the situation and stating where and when he would return the documents to NARA. He also promised that his client would fully cooperate with the US government. Now, Pence had previously said he didn't have any classified documents in his possession, but it wouldn't be surprising given the recent news that Pence decided to search just in case. And it's fair to assume that all of America's prior leaders are probably undertaking a similar search. We're looking at you, Jimmy Carter. Now, if Garland follows recent precedent, then it's likely he will appoint an independent counsel for Pence as well. It's not unusual for NARA to ask ex-presidents to return documents, and given the volume of documents created during a presidential administration, it's not unusual for some stray documents to be found in storage. But the number of classified document scandals demonstrates that people are not following procedure and also hints at the overclassification of documents, which is its own separate issue. But the way that Biden and Pence handled this discovery highlights how much Trump deviated from the norm here. He allegedly refused to give the documents back and continues to insist that he has a right to keep them. So we'll see if any criminal sanctions are handed down to Biden or Pence for storing classified documents in their home. Because, and I can't believe I have to say this, homes are not for storing classified documents. They are for making delicious home-cooked meals, which you can get with today's sponsor, HelloFresh. They're so delicious that they feel like they should be illegal. Because HelloFresh is a great way to eat delicious fresh food while still being healthy. It's a great way to start the new year right. In fact, HelloFresh has a whole variety of calorie smart, carb smart, pescatarian, and veggie options, and you can customize it however you like. HelloFresh delivers fresh quality produce from the farm to your door in less than a week. So you can enjoy favorites like the falafel power bowl, seared steak and potatoes with béarnaise sauce, or Southwest pork and bean burritos. Now, I'm a do-it-yourself person, and I have to say I was initially skeptical about HelloFresh. I'm a pretty good cook, so I didn't really think that I needed the help, but I actually loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I'd never try on my own. HelloFresh generally keeps everyone's favorite meals and then rotates new ones in all the time. In fact, I usually increase the size of my HelloFresh servings so I can enjoy the leftovers for lunch, which saves me even more time. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time because HelloFresh cuts out the meal planning and prep, and recipes only take 20 to 30 minutes to cook. Literally less time to cook than it would have normally taken to do the shopping itself. And it's also incredibly sustainable because the packaging is almost entirely made from recyclable or already recycled content, and HelloFresh's carbon footprint is actually 25% lower than that of meals made from store-bought groceries, and 72% cheaper than dining at a restaurant. So if you would like to try HelloFresh, you can go to HelloFresh.com and use the code LegalEagle21 for up to 21 free meals. Yes, you can actually get 21 free meals, and that includes free shipping. Or you can just click on the link that's on screen right now or down in the description. So again, for up to 21 free meals, go to HelloFresh.com and use the code LegalEagle21, or just click on the link below. Plus, clicking on that link really helps out this channel. And after that, click on this playlist over here for more Legal Eagle, or I'll see you in court.